Have anyone present on that matter?
I am here. You're.
All right, thank you. Mr. Finch is present. It does not appear that Ms. Smith Finch is present. This is a hearing regarding a parenting time violation filed by the father, Mr. Finch. We were here previously. Ms. Smith did not appear. The court ordered that the matter would be adjourned in an attempt to locate Ms. Smith with the likelihood of an issuance of a bench warrant if she did not appear. Mr. Finch, do you have any additional information on this matter?
Yeah. Recently, I've learned that there's a possibility that they've jumped again from what I told before was Argonia, Kansas, and through my own snooping around, and I found out that the gentleman that she left and went to Kansas with the kids now has just gotten a job in Fort Smith, Arkansas, which is quite a distance from Argonia, Kansas. So I suspect that they may have jumped in from Kansas to Arkansas now. I suppose I don't need to say that I'm very concerned with the welfare of my daughter and my stepson as well. This is very unusual behavior for her. All ties have been cut off. I haven't spoken to my daughter in months. So yeah, I very much look forward to something being done and her being pulled into line here.
What is your current parenting time order, sir, if you know offhand?
It's basically summer vacation, some during winter vacation, and then here and there, you know.
Okay. I see
Whatever.
it. Oh,
Yeah,
it looks like
no,
it said,
pardon?
is it sent? So I see in your judgment of divorce in 2017, it indicated that parenting time is she would have the child during the school year, you would have spring break, winter break, and split the summer. Is that your understanding as to the last order in this matter?
Yes, Your Honor. And this is the second time that she's moved like this without notification of the court or myself.
Did
The
she?
first time was from Gaylord to Holland, Michigan, or West Olive, Michigan, down by Holland. She wasn't held accountable for any of that, and now she's skipped and off to Kansas.
Did you have parenting time over the summer or not?
I did not.
And so at that point, had she already moved, to your knowledge?
She moved from the Gaylord area to West Olive, Michigan, in I want to say that it was right after, or actually before summer. So it would have been in the spring or early summer of last year. In the distance, too far for me to go. I'm all the way up at the west end of the Upper Peninsula, right on the Wisconsin border, Michigan.
All right. Well, for this particular hearing, we were here on the show cause and no other matter. So based on what we're here for today on the show cause, given her failure to appear, I will recommend a bench warrant in the amount of a $900 bench warrant with $100 in costs. And sir, you may want to investigate what other options you have or speak to an attorney as far as addressing other issues in this matter. Given this,
okay,
the
now,
current
now who would I give this information to that I have as far as their whereabouts at this time?
Your caseworker.
Okay. All right. I will call her after our time here.
All right. Well, that's all I'll do is issue a bench warrant at this time. All right, anything else, sir?
not off the top of the head, other than, like I said, I'm concerned about her well-being. I haven't heard from her in almost a year. She
Well,
is
there may be other steps for you to take.
I have no ability to contact her. She changed her number. And like I said, I'm trying to track her down using social media and whatnot. And like I said, as of the 21st of this month, her boyfriend or husband, it appears, has received a fork truck license with his new employer in Arkansas, Fort Smith, Arkansas. So I suspect that they may be in that area.
All right, I would say contact your caseworker. And again, for today's purposes, we'll issue the bench warrant. You may want to speak to someone else or investigate other further options that you have to address the matter. That's all we can do for today, okay?
Okay.
All right, thank you. You're all set.
All right, thank you, sir.
We have parties on that matter, Alexis Dunham.
Yes, they are, Your Honor. Both parties are present. And Your Honor, I'm Mary Ann Kirschbaum. I represent Lee Barnes in this matter.
Thank you. And Ms. Dunham, you can hear me okay?
Yes, I can.
All right, thank you. So this is a order to show cause for a failure to attend the SMILE program. My understanding is Ms. Dunham has now completed that. Mr. Barnes, Ms. Kirschbaum, what is his status with getting that completed?
Well, I wanted to explain that this is partially my fault because unfortunately, the two show cause orders were scanned in as one document by my firm. And I sent the orders as one document, and I only realized the top 2 pages were there. And I had basically sent the document, but told my client, this is show causing Alexis, and I will see if we both have to appear. And literally until yesterday, I didn't realize the 2 documents that my client show cause was tacked onto the bottom of Ms. Dunham's show cause. So I would have obviously advised him to immediately take care of the SMILE program, and he did not have the benefit of my advice due to that mistake on my end. So I am sure that at this point he understands he has to comply, he has to participate in the SMILE program. And so I would just ask that the court give him another chance to comply.
Okay. I'll certainly do that. So Mr. Barnes, have you investigated and looked into when you can take the class yet?
Yeah, I saw that it's the 3rd of February between 6 p.m. and 8 p.m.
All right. And that's when you're going to take it?
Yep.
All right. What I will do then is adjourn this matter to February 19th.
All righty.
But I'll indicate that upon proof of completion, that hearing would be canceled.
Your Honor, I will be out of the country on February 19th.
Okay. Are you gone February 12th?
No, but and I'm just checking right now. I'm just checking my calendar, Your Honor.
And as indicated, if it's completed, then we would just cancel the hearing.
Right, I understand. I just want to make sure. I had a couple trials coming up. No, I'm free on February 12th. So would that be February 12th at 9 a.m.?
Yes, we'll make it 9 a.m.
Thank you, Your Honor. And I had one more item to report is I've already completed a proposed judgment and a proposed final uniform child support order. And it basically mirrors what's already in order in place, but it will be sufficient to just close out the case. So we won't have to keep coming back to court. And what I'd like to do is I'd like to be able to send it to both parties for their electronic signatures. And what I need to have though is Ms. Dunham's email address in order to do that.
Ms. Dunham, do you want to share that now, or do you want to just contact Ms. Kirschbaum and provide it?
I can just give it to her now.
Thank you.
Okay.
You're welcome.
Go ahead.
Okay, it's Dunham Alexis.
Okay, so there may be, if there's something that I need to ask a question regarding, would I be able to contact you by phone as well?
Yeah, that's fine.
Okay, thank you.
Yep.
All right, so we will adjourn this matter out, and as indicated, as long as get that completed, Mr. Barnes, and let the front of the court know that that is completed, that hearing would be canceled.
Alrighty, I got one more question too. So is that just via Zoom too, or do I have to go to like Grayling? Because that's where it's hosted.
No, it's by Zoom.
Alrighty, sounds good.
All right, thank you everyone for appearing. You're all set and can sign off.
Thank you.
So much. Have a great day.
8
Thank you.
p.m. Ms. Johnson, can you hear me okay?
Yes, I can.
All right, and then Mr. Johnson, you're still with us?
Yes, I am.
All right, and sir, this is your objection to a child support recommendation, is that correct?
Yes, it is.
All right, so go ahead and state the basis of your objection.
Well, we have already agreed on everything, so I think we can. I can pretty much just drop it.
All right, well, what does just drop it mean? So you're not objecting to what the order indicated, the child support order?
Right.
Okay. And Ms. Johnson, is that correct?
Correct. Last week I had submitted our judgment of divorce that we signed, as well as the child support order and a child support deviation addendum that we both signed.
All right, well, let me review that, 'cause I didn't realize there was an agreement then. So you're not adopting the recommendation that was sent out, you're doing something different, correct?
Correct.
And that's deviating to 0 for child support?
Correct.
Is there any assistance in this case?
No.
There is not.
Okay. You guys have a hearing before the judge, I think next week, is that correct?
We do.
All right, that would, with your intent then to finalize that judgment that has been submitted?
Yes, correct.
For the court, if I said his objections withdrawn, then that means that order would go into place.
It's an informational.
Oh, it's informational only? Okay, perfect. All right, then I'll indicate that the objection is withdrawn. Any questions, Mr. or Mrs. Johnson?
We do have another hearing set for February 12th, and that was to address the parenting time related to this same type of objection. So I didn't know if that needed to be canceled now that we have an agreement.
Okay, that was your motion also, Mr. Johnson, is that correct?
That's correct.
Are you asking the court to, are you withdrawing that motion?
Yes.
All right, so I'll indicate that that motion is withdrawn and parties do not need to appear for that date, which I think was February 12th, so the court will remove that from the docket. All right, anything additional?
I was wondering if the front of the court would be able to then send or forward the judgment of divorce once it's signed and approved by the front of the court to the clerk's office for Judge Hunter, as I'm 6 hours away, so I wouldn't be able to come pick that up and bring it to the clerk's office.
All right, I will defer to the front of the court.
With the filing fee.
Pardon?
There may be a filing fee, so I'm not sure if we could just forward it on.
Okay.
But what we can do is we can forward it on, and then if the clerk sends it back, we can reach out to the parties.
Okay, all right, so they will attempt to forward it on, make sure
Okay.
there's no fee that's paid to do that. You know, once it's signed by the judge, there will likely be a fee unless that was paid up front when the divorce was filed.
Sure.
But they will do that. If there's an issue with forwarding it after they sign it, they will reach out to you, okay?
That sounds good.
All right, anything else?
Not from me.
All right, Mr. Johnson, anything else?
No, sir.
All right, thank you both for appearing. You are all set and can sign off.
Thank you.
Thank you.
So we have Mr. Bubner present. Sir, can you hear me?
Yes, I can, sir. Can you hear me?
Yes, sir, thank you.
Yep.
All right, once again, we do have somebody on an iPhone. The court has called the case of Troy Bubner versus Emily Berry. If Miss Berry is present, I need you to unmute and identify yourself. All right, having heard no response, the court will move forward. So, Mr. Bubner, this is your objection to a child support recommendation, is that correct?
Yes, Your Honor.
Okay, what is the basis of your objection, sir?
I guess a couple of things I guess I didn't fully understand. The reason why I agreed to let her move out of state and no child support was ejected was because the affordability to see my child still. Um, I'm not completely objecting to the full amount. I'm objecting. I love my son. I want to support him. I care for him, but I also want to be able to see my son. And alone and just seeing my son in gas, I drive 1,600 miles. I drive 14 hours in a day to see my kid, and it's $400 just alone in gas, and then not including when I have him. So I am not requesting the court fully. I'm just asking the court to maybe look at it differently and maybe lower the price of it so I can still have the ability to see my son because he lives in Kentucky and I live in Michigan.
Any discussions with Miss Berry regarding this?
I have tried talking to her about it. I tried asking her for agreement. I said that I would pay the insurance that is $211, and then also give her another $200 for coverage for like whatever he needs. And she said, "Oh, I'll think about it." And then she was telling me that she agreed with it. She thought it was too much, but then when it came down, I texted her again recently saying like, "Hey, like, is this okay? Like, we can talk about it with the court, blah, blah, blah." And she just completely backed out on me and said, "Oh, we'll let the court figure it out, blah, blah, blah." So I've tried communicating with her about it, and it's, I mean, it's gotten me pretty much nowhere. But like I said, I want to support my child. I love my kid. I don't want to lose him. So this is like that's why I disagreed with it, because doing this, I won't afford to be able to see my son anymore.
All right, thank you.
Yep.
I mean, certainly, if she were here and there was an agreement to make some changes, I could consider that as an
Right.
agreement between parties to deviate. But I don't see that she is present.
I'm so sorry, sir. I was having trouble with my microphone connecting to my
Okay.
app. Sorry.
Perfect. So we do have Miss Berry present then. Thank you, ma'am. So, ma'am, he is requesting some type of decrease in the support amount. Kind of based on the history of the case, where at one point there was an agreement for no support, and then support had to be calculated because of the receipt of public assistance and benefits. So what is your position on his request to pay a lower amount?
I do feel like the amount that you guys came up with is fair. He stated in the first sentence of his objection letter that I agreed that the amount was excessive, and that is not true. Like I said, I do think that amount is fair, being that I do still have to pay the same amount of money for gas to meet halfway as he does on top of everything else. So
Didn't you agree back in 23 that there would be no support?
at that time, yes.
Okay.
May I
You're
say
not
something? Oh, sorry.
Sorry, sir. So you're not in agreement, Ms. Berry, to deviate at all to what is in the recommendation?
No, sir.
Mr. Bubner, anything else that you'd like to say?
Yeah, we do not meet halfway. She drives 4 hours and 24 minutes, and I drive 6 hours and 10 minutes. So overall trip though wise, I drive 4 hours extra than what she does. From the provided addresses, from the addresses on the our court papers.
And I'm not trying to argue, but I've looked up that the mileage and everything through GPS from his address provided on the form, and then my address, and it is like right at the same mileage. And
Anything else you wish to?
if we need to, like, adjust that a little bit so he doesn't have to drive farther, that's fine. But whenever I first moved to Kentucky, the address that he had was in Gaylord, and now it's in Atlanta. And he never communicated with me to get that changed, because I'm sure Atlanta is a little bit farther. But that's something I'd be open to if he wanted to move the location. So it is pretty fair.
Okay. The two of you can certainly have that discussion and come to some type of agreement. All right, but however, given that there is not an agreement to deviate, I'm going to deny the objection since there is no agreement to deviate.
Okay.
All right, any questions, sir?
No, sir.
All right, Ms. Berry, any questions?
What kind of happens now moving forward?
Well, I've denied the objection. He has a right to seek further review of that decision. That information will be provided in the form that is sent from the front of the court. He has 21 days to file a new objection before the judge in this matter. If he does not file that objection, then the child support recommendation goes into place. If he does file that objection, then the judge would hear the matter.
Okay. Thank you.
Your Honor, may I ask one more question? I'm sorry.
Yep.
This is all new to me. Is there back pay? I've been told about that before. I don't know anything about it. I'm just curious. I wanted to ask about it.
If there's back pay?
Yes, I've told that's a thing before that people get when they get hit with child support. That's why I was curious.
It would be the date the judge signs the order,
Okay.
potentially, unless it's objected, then maybe something different.
All right, so it all depends. I mean, it looks like the support order would go in effect the day the judge signs it, so
Okay.
there should not be retroactive support.
Okay, thank you.
Addition. Okay.
Okay.
All right, thank you both for appearing. You're all set.
Thank
All right,
you.
thank you, Your Honor.
1 and 2. Mr. Rivas, can you hear me okay? All right, you are muted, sir.
I can hear you.
Thank you. And then Ms. Bauer, but it looks like perhaps it's Ms. Bolden now. Is that correct?
Correct.
All right. Thank you. So we do have both parties present. Sir, this is your objection to a child support recommendation. Is that correct?
Correct.
All right. Please state the basis of your objection.
I was just looking at my income on the child support order, and it
Okay.
looks like if I was doing my math correct, that it was like $20,000 or $10,000 higher than what I actually am base salary, because the paychecks I submitted were on overtime that I was in North Carolina for the hurricane. So I don't know.
Okay. You typically get overtime throughout a year?
Most of the time, yes, but I mean, it's not as much as I have gotten this year with the hurricane and everything else that's happened. All the travel.
In calculating his income and addressing overtime, did the court have a chance to review prior year earnings or anything like that?
I believe the earnings reviewed were for the year to date from the pay stub dated November 21st of 2024. Based on that, the overtime earned to that point, the monthly amount was figured out and divided by 12 months. And then the gross earnings were subtracted minus the per diem and then minus the overtime. And then we figured out the regular earnings based on that and figured out the weekly income.
Okay. So, sir, is this a job that you've had for several years?
Yeah, I've worked here 9 years. I think this is my 10th year.
Okay. So, front of the court, the only thing that you had was just some recent pay stubs and not prior tax returns. Is that correct?
I think so. I can take a look at the file.
Sure. Okay. Do you have, sir, do you know if you submitted any prior tax returns, for example, 2023 or 2022?
I am unaware if I did or did not.
Do you have those available?
I can get those, yes.
Okay. So what's tricky with overtime is, some people have pretty consistent overtime, other people do not. The court has to consider overtime, but we like to, if you have one time where you're getting a bunch of overtime and then you're not going to typically have that, we do want to try and get it as accurate as we can. So one way to try to get a good accurate read is to look at prior years also. I'm guessing you probably don't have your 2024 taxes prepped and ready to go yet?
Nope, not yet.
Okay. But that's the only job that you work? Do you have any other employment or not?
Nope, this is the only job.
Okay. So front of the court, you must have had then is 2024 full year earnings or not?
Yeah, it looks like up to November 21st based on the most recent pay stubs.
Okay.
So
you could submit, sir, your final pay stub for 2024.
Okay.
And then if you also submit your 2023 and 2022 information, the court can look at an average as to what you typically average as far as overtime, and do that over a course of time to make a more accurate representation of what your overtime might be.
Okay.
So I will allow you to submit that additional information for the front of the court to review. And then any other issues with the objection, sir?
The only other thing would be, do we have a set parenting schedule? Do you see that in there? I know that's not the support matter, but.
Well, I mean, I can say that based on the file, it looks like the last order was in 2023.
Correct.
Pairing time would be week on, week off. Exchanges on Monday. Holiday pairing time shall follow the guidelines.
Okay. If there's any extra parenting time or switch in parenting time, is that something that needs to be recorded?
No. If you guys have an issue going on, you might have to be more specific with your pairing time, but you don't have to report any changes that you guys make unless if you're making a new order, a new agreement, and you want it enforced, then you do have to go through the steps to get a court order.
Okay.
I noticed though that your objection had a few other bullet points. So you had written on here, healthcare premium has one additional person covered.
Which I did talk to the caseworker and she said that that was not the case. I was just reading it wrong.
Okay. All right.
So I got that question answered. And then
so you're all set then with your objections. We'll get that information from you.
I believe so, because you guys have that I have him on health insurance now, so that increase on my end.
Okay. Ms. Bolden, any questions or any comments that you'd like to make?
I do have one question. I am currently self-employed. I started a photography business August 30th of last year. And I am only making about $200 right now. The market is super saturated here in Gaylord. And I think winter time's kind of hindering that too. I'm spending more a month on software than I'm even making. So I am in the process of dissolving my business. And therefore I'm not going to have any income at all. Do we still run with that $2,700 per month that's on there right now? That would be my potential earnings.
We most likely would, because then if that's kind of the history of what you're able to make, during a period of underemployment or unemployment, the court can still impute income based on a prior history.
Okay.
All right, so I will grant the objection. I will give you, sir, 14 days to submit any new financial information that you wish to submit, which should include your final pay stub for 2024, as well as tax returns for 22 and 23, so that the front of the court can get a good average of what your typical wage is based on your overtime throughout the years.
Okay, I have plenty of time within that 14 days to do that, so perfect. Thank you.
All right. And then a new recommendation we prepared, you both will have the chance then to object to that recommendation also.
All right.
Okay.
Thank
you
you
both for appearing. You are all set.
Thank you.
Do we have the parties on that matter present?
Yes, I'm here, Your Honor.
Thank you. And Ms. Salo, this is your objection, is that correct?
Yes.
And what is the basis of your objection?
She recently has gotten a new job back in December, and I just want to make sure that she reports that income and you guys can calculate that into the child support.
Okay, Ms. Colton, is that accurate?
Yes, that is accurate, Your Honor. I recently started working at Enterprise, probably about a month and a half ago or so. So yeah, that is accurate. Yes.
Or do you know if that job was used in this recommendation?
I don't believe so.
Okay,
The wage was $14.53 at $25 an hour.
All right, so Ms. Colton, can you provide some pay stubs from that job to friend of the court?
Yes, I can, Your Honor. And there's a couple of things that I would like to touch on as well.
Okay.
So this child support case and custody case has been going on since, I want to say February, March of last year. I have not received any child support. This has been almost a year now. He recently got his second DUI. He could be possibly facing jail time. I'm possibly going to have the kids full time, and I feel like lowering child support is not going to be beneficial going forward to his possible court date that is coming up, and I'm unsure of that. And I'm having to transport the children to all their appointments. He has to have a driver. He no longer has a license. And right now, like, I've been kind of in a bind this entire year. And I feel like the child support just like keeps lowering every single time he wants to go back to court or doesn't agree. And I kind of want to, after I give you guys my statements and stuff, I want this to come to an end to where I'm not having to struggle as a parent with 5 children right now.
Okay. So if there is at some point a change in the overnights, then you would have the right to seek a modification if there is a change in the overnights.
Okay.
But at this time, obviously, we don't know what's going to happen. So if there is a change in overnights, that would be your way to address that, is to file a motion to modify that.
Okay.
Okay. All right. So I'll indicate, ma'am, that you need to provide that information at least within 14 days. And then the friend of the court will prepare a new support recommendation.
Okay.
All right. Thank you both for appearing. You're all set.
Thank you.
01DS. Do we have parties on that matter present? All right. If you are present, I need you to unmute.
I don't know how. Hold on.
You're unmuted, ma'am.
Okay, I'm like, I don't know how.
All right. And Mr. Unmuted also. Mr. Royster, this is your objection to the child support recommendation. Is that correct?
Yes, sir.
Okay. Please state for the court what the basis is of your objection.
Well, the year you did the review for the $328 a week, I believe I made like $74,000 that year. I only made that much money because I was getting bonuses and I was working every day. I now have a new job. I'm going to be making probably close to $20,000 less a year.
All right. When did the new job start?
Around December, around our last court hearing, when I told you I got a new job.
Okay. So you're saying that what this current recommendation was based on your old job? Is that what you're saying?
Yes, sir. We went over this in our last hearing. My boss also sent in a wage verification form. I went from making $250 a day to making $205 a day, and I work around $5 or 5 days a week. My old job, I work 6 days a week, got $250. I'm making at least $300 a week less at this new job.
All right. Friend of the court, can you shed any light on how his was calculated?
It was based off the questionnaire, that you provided on the questionnaire along with pay stubs. the wages were both broken down and compared, and it looks like what you put in the questionnaire matched what pay stubs ended up to be. So that's what was used as the monthly income.
Okay. So I see a monthly gross income, it looks like, of 5,348. And you're saying that's inaccurate, Mr. Royster?
Yes, sir.
And the court's indicating they they based it on what you provided, but you don't think that is true?
No.
And how much do you make a day? You said 205?
Yes, sir.
Working how many days a week?
5 days. There's some days I work 6, but it's normally 5 to 6 days a week is normally during the holiday season. The way the pay stubs look, it makes it look like I'm making $60 an hour, but that's not how it actually is. My boss sent in the wage form explaining how it actually works. FedEx needs it put on an hourly basis, but I get paid a daily wage. The check stub, it looks like I make $60 an hour. I do not make $60 an hour. It's just a daily wage at 205. When you guys did the last review, it was $250 a day at 6 days a week. And that specific year, I know I made a lot of money because I worked every day and I got multiple bonuses throughout the year because we were short-handed and I was running that company. I'm no longer doing that. I switched jobs because that company may be failing and I'm able to take days off at this job whenever I need to so I could actually start seeing my kids more. I wasn't able to take any days off at that job.
Okay. Looking through the file a little bit here, I do see it appears from the employer indicating that you're paid $205 a day, regardless of the number of hours. It's a salary position. And you switched to that type of payment on around what time, sir?
The end of November, I believe it was close to December, right before the holiday season.
But you indicate that it's not always 5 days. Sometimes it is 6 days. Is that correct?
Yes, mainly during the holiday season, which is peak time at FedEx, obviously around Christmas time. Any holiday, like Valentine's Day and things like that, we pick up. But other than that, it's only 5 days a week.
Do you have any recent pay stubs also that you could provide?
Yes.
From the court, do you know if this was calculated then on him making that amount, the 205 a day, working 5 days?
I use his pay stubs.
Okay. There's been kind of a change in apparently the way he is getting paid recently. We didn't have a very large sample to make that based on. So I'm inclined perhaps maybe to allow him to submit some more recent pay stubs so we can get a better look at what is going on now that we've got a little more time under our belt with him under this different position. I don't think we need another employer verification, but simply just your, pay stubs, sir, certainly throughout January, if you can provide those. Any issue with providing that, sir?
There should be no issue providing that, no, but this is killing me. I can't keep doing $328 a week until all this is figured out. I've exhausted all my savings. My bank account's in the negative. I'm falling behind in my bills. Like I can't keep doing this until we figure this out. We have to keep doing something else each time we go to court, and I can't do it anymore.
Well, I mean, obviously you had a job that appears, income dropped. So the court needs to get a better sample of what you are making, and then the court also has to determine whether or not you are, underemployed based on your history.
We went over this
So-
2 months ago that it dropped, so. Like,
All right.
we already went over this and nothing's changing now that we're back in court again. That's my problem, is we keep going back in front of you and nothing changes, and I've already explained to you that my income
You're
changed.
certainly
last
free to
time.
have a problem, sir. That's your every right to have a problem, but I'm trying to make sure we get this as accurate as we can. Ms. Carlskin, anything that you would like to say?
No.
All right. So I am going to allow Mr. Royster to submit some additional pay stubs. I'll give you 7 days, sir, to provide any pay stubs that you have. I would say certainly for January, but I think if you've got some for December, that should be provided also. And in front of the court, we'll take a look at the accuracy of the income and either make a change or not make a change, but you'll have the right to object to a new recommendation. All right, that does conclude the matter. Make sure you provide that information, sir.
Whatever.
Thank you.
You're welcome. Do we have the parties on that matter present?
Yes, Your Honor. Elliot Blumberg on behalf of the plaintiff, Mr. Ferris, who's appearing via Zoom from my office.
Thank you.
I'm also present.
All right, I think we do have the parties present and counsel. Mr. Blumberg, as plaintiff's attorney, what is the status of this matter?
Judge, this divorce action was commenced in October of 2024. Ms. Ferris was served with the pleadings, has not yet filed a response. The parties have been separated and are basically effectuating a week on, week off shared custody arrangement of the 3 children. My initial reaction was, because of her failure to file some type of responsive pleading, to schedule an evidentiary hearing. But if the parties have come to an agreement and this is what we wish to do, I think we can have a temporary order until the divorce is final.
All right, so you're asking for a temporary order of week on, week off parenting time?
Yes.
All right, Ms. Ferris, what is your thoughts on that?
I am in agreement with that. We've been
Okay.
doing that and it's been working very well for both of us.
Okay, what day are you guys switching?
On Fridays.
Okay.
So
You
I'll
switch
drop
at a
off.
partic-
Sorry.
Sorry. Go ahead, let me know how you do the exchanges.
I drop off on the children daycare and school, and then he picks them up. And then vice
Okay.
versa on my week, I pick them up.
Right. Well, given that information, I think we can put a stipulated order on the record if the parties are in agreement. Is that correct, Mr. Blumberg? A week on, week off with exchanges on Friday?
Is that, yes, I think that's what's been going on.
I do think a different schedule of like a 5-2.
That's, Judge, I guess there's some variation to that. My client is actually seeking, again, I don't think we need to schedule an evidentiary hearing, but if Ms. Ferris can reach out and contact my office, I haven't defaulted her in this case, but if there's some details we can work out, I would appreciate it if she'd do that.
All right, do you just want to adjourn this matter then, Mr. Blumberg, allow the parties to see if they can reach an agreement, and then you can submit a stipulated order?
Yeah, I think that would probably be the appropriate way to proceed.
Okay, so we'll adjourn this out about 60 days to see if the parties reach an agreement prior to that. If not, then we'll be back in front of me in 60 days.
All right, sounds good. Thank you.
Thank you.
All right, any questions, Ms. Ferris?
No, thank you.
All right, thank you. You both are set.
Okay.
18DS. Do we have the parties on that matter?
Yes, Judge. Elliot Blumberg on behalf of the plaintiff, who is just coming into my office from the waiting room. She will be appearing via Zoom as well.
Thank you. Do we have Mr. Richardson present?
Yes, I'm here.
Thank you. Mr. Blumberg, what is the status of this matter?
Your Honor, this is a recently transferred case from Mount Morenci County Circuit Court. There was pending in that court a motion to change custody. That matter is pending to be heard by this court. So we would be asking the court to schedule an evidentiary hearing at this time.
Okay. Mr. Richardson, anything that you would like to say?
Yeah, I'm here today because I'm wanting to have visitations with my kids. I haven't seen them since Father's Day weekend. And at the moment, I'm not sure where Darian lives, and she has not let me see my kids.
All right, well, we would set the matter then for an evidentiary hearing. I do have a date that opened up on February 10th. I don't know if that's available for you, Mr. Blumberg. That's pretty quick, but we do have that available. February 10th at 9 a.m.
I'm in mediation that day, Judge. I'm sorry.
Okay, and then we're looking at, if we're going to go more than an hour, we're looking at April 23rd at 1 p.m.
I'm sorry, April 23rd?
Yes, at 1 o'clock.
I'm open.
All right. Mr. Richardson, do you have any conflicts with that date?
Yeah, I would like to see if there's anything sooner, because that puts it at almost a full year of me not seeing my children whatsoever.
Do you have a pairing time order that's in place already, sir?
We had one in Atlanta that was for me to pick up my children on Fridays at 4 p.m. and take them home on Sundays. But since she's moved downstate, that she has withheld visitations.
Okay.
And she withholds communication with me about visitation time.
Unfortunately, that's the earliest date I can give you. There are certainly factors that come into play based on whether or not parties are following an order or not, and have good cause to not follow that they are not. So those issues can certainly be addressed at the evidentiary hearing. But are you unavailable on April 23rd, sir?
I'll be available.
Okay. So we will set this matter for an evidentiary hearing on April 23rd at 1 p.m. That is a in-person hearing. So the parties and counsel need to be present. It looks like at least one of the children is 7 or older. Is that correct?
Yes.
Okay. So I would do a preference interview with any child that is 7 years or older. Any questions, Mr. Blumberg?
No, Judge, thank you.
All right. Mr. Richardson, any other questions, sir?
So am I going to have to wait until April 23rd for this hearing to be able to have visitation with my children?
I've not made any changes to anything today. I have to wait and have an evidentiary hearing. So whatever order is in place is what is in place.
So that means I just go to the courthouse and get my papers. And since it says I pick up my children, I get my court papers, and then, well,
I
does
can't
she still
give you
live in
legal
the
advice.
My
I can't give you legal advice,
does she
sir.
still live in the
All
same
right.
place? Because last
All right,
time she had moved again.
All right, Mr. Richardson, I can't give you legal advice. All I can say is whatever the order is what is in place at this time. You have the right to file any motions or any requests that you won't wish to file.
I've been filing motions for the past 10 months.
All right, well, I don't know what happened in the other court. It was used to be in another court. Now it's been transferred here. We have set the matter for a hearing.
Thank you, Judge.
All right, thank you. Do we have anyone present to call the matter of?
I am present, Adriana Norman.
And we're still here, Attorney Lee Voice for Adriana Norman.
Thank you. It does not appear that the other party is present. Looks like we were set for a status hearing after mediation. Counsel, what would you like to report?
Your Honor, we did have a mediation. We have a resolution, I believe. The parties have been operating under a joint parenting schedule that we've created over numerous mediation meetings. The matter just got, I guess, resolved at the front of the court, we do have a recommendation that my client is fine with. Adriana, I haven't spoken to you about pickup and drop offs and parenting. I know that we had one issue, Your Honor, and that is with the joint clause agreement that neither party would consume alcohol during their parenting time. My client has photos of Mr. Sigavus not complying with that order, as a picture of him in a bar drinking a drink. Adriana, I'm not sure what her position is on that. She did bring it to my attention that he's not complying with the order. But finally, more importantly, I think, Judge, is the tax exemptions. Both parties are working. My client would like to have even years, starting with this year. Other than that, Adriana, unless I've missed something, unless there's an issue with parenting time or scheduling pickup and drop offs, is there?
Nope, we've actually kept in contact. Whenever one of us don't send William to daycare, we just keep in contact about meeting at 6 p.m. Because with us sending him to daycare, we just normally pick him up right after and then start our parenting time then. So
What's your position with the alcohol clause in the mediation? Do you want it to remain? Do you want it to
I think
be?
it should remain. I mean, if he is wanting to hold me accountable for it, I feel that he should be held accountable for it as well.
Well, then you have to file complaints with the friend of the court, and then they can follow up on that. I don't know if there's anything the referee can do right now.
Okay.
But is the tax issue something that you would like to start this year?
Yes.
For your exemption, you to take the child as an exemption?
Yes.
Okay. Your Honor, I don't know that I have too much more to add to that.
Okay, I do see that there was, yes, a stipulated order resolving, it says a stipulated order resolving child-related matters back from December that the court did sign and enter. And this status conference was scheduled long before that, so maybe we didn't actually need the status conference, I guess, since there was a stipulated order, but I don't know if there was a final custody order prepared.
Yeah, no final order. That's what I thought we were kind of here to do, to solidify.
Okay. Well, I mean, if you don't have a final agreement, then I would say let us know and we could set the matter for an evidentiary hearing if there are other issues to address, or if you and the other counsel can solidify those into a final judgment, that can just be submitted.
I'm not sure why Mr. Gurumurti is not here today, but I'll reach out to him. His client filed before he retained counsel. I'll see if Mr. Gurumurti wants to draft a final order. And if that's the case, then we won't even need to reschedule this, I presume.
Correct.
Very good. I appreciate. Is everything okay over there?
Lots of snow. My son is happy. Not much school lately, but
I bet.
We may have to have you come on the record for that final order, just to put everybody under oath and go through the best interest issues. So if you guys have a final order, what you probably should do is get a court date to appear before me. Just have everybody, I'll hear from both clients just to make sure that they agree to that and get all those terms. But if you guys do have an unresolved issue, then also just contact the court and we will get a date to address that. And if we need an evidentiary hearing, get one scheduled.
Sounds good. Thank you, Your Honor.
All right. Thank
you. I'll talk to you, Adriana.
Okay.
Yes, I'm here, Your Honor.
All right. Thank you. So this is a status hearing regarding a medical issue. Friend of the court, anything to update the court on?
Mr. Huck did drop off information from his orthopedic doctor. From what I can indicate here is that he's I don't know when the next appointment is with them, but he is on, off of work for at least an additional 12 weeks.
Mr. Huck, is that correct? Sorry, sir, you got muted again.
Yeah, sorry about that. Yes, that is correct. I actually dropped off paperwork at the front desk of the front of the court office.
Okay.
Yeah.
When do you go back to the doctor?
The doctor's actually being let go from Bay Street Orthopedics, and he's going down to Muskegon. So right now they're not booking appointments yet. I just had my follow-up Thursday afternoon. So I'm gonna, yeah, I have to contact them. They said I'm not gonna have a follow-up for 8 weeks.
All right. And so you're off all work at this time?
Yes.
So what I will do is adjourn this out a bit. I'll adjourn you to about April 23rd. And we can get the update then. Obviously, if you have any appointments before then, make sure you let the caseworker know what the results of those appointments are. Any questions, sir?
No, sir.
All right. Thank you. You're all set and can sign off.
All right. Thank you.
79 ES. We have the parties on that matter present. All right. I do see a upside down Elizabeth Smith.
I don't know how to flip it. Sorry.
Okay. All right. We do have Ms. Smith present. And this is your motion. Is that correct, ma'am?
Yes, sir.
And what are you seeking to do?
I am trying to get help paying for medical insurance.
Okay. Are you currently then providing the insurance?
I am. I make too much. My kids and I no longer qualify for Medicaid, so I am paying out of pocket.
Okay. And that was not factored in the last support recommendation then? Okay.
Correct.
All right, so I would indicate that I would grant the motion. The court will prepare a new support recommendation based on the healthcare costs. Has that documentation been submitted to the front of the court yet? Okay. I see that you wrote figures down in your motion, but you need to supply pay stubs or something that shows the payments that you are making, okay?
I can submit what I had, but I actually am just switching jobs currently. So those numbers will no longer be correct here soon. I have to wait. I'm trying to get a hold of the old employer to find out when the insurance will no longer be active, and I will have to get insurance off of healthcare.gov because the employer I have now does not offer health insurance.
Okay.
But I am talking to Tara. Might be Tara.
Yes.
Yep, I'm in touch with her.
All right, let's go look at something in the file real quick.
I can submit the paperwork for what I've been paying though, because I have been paying out of pocket since October.
Okay.
So I paid for October, November, December, and January.
All right, so you did pay for January. So I would say yes, do that, submit support for the months that you have paid.
Okay.
And then, do you know when you're gonna have this other issue resolved as far as the new insurance? Is that something you're looking into now?
I am currently working on it in order to even apply for healthcare.gov. My old insurance has to be canceled. I'm waiting for the administrator to contact me and let me know when that plan will no longer be in effect.
Okay. All right, so I'll indicate that you need to submit the prior payments as well as then keep your caseworker notified as to when you'll start making be required to make a new payment, which will probably start, I'm assuming your insurance will be terminated here shortly. So just make sure you provide what that new cost is going to be also.
Yes, sir.
And recommendations will be prepared based on those costs.
Thank you.
Okay. All right. You're all set. Thank you.
Thank you.
DM, if council could please place their appearances on the record.
Good morning, Your Honor. Elena Lentz for the plaintiff, Michelle Pegg.
Morning, Your Honor. Jennifer Dusman-Coy on behalf of Aaron Pegg, who is present in the Zoom courtroom.
My understanding the parties have a resolution of all matters. Is that correct?
Correct, Your Honor. My understanding is the front of the court did have a chance to look at the proposed consent judgment and approved the language. And I believe we are here just to solidify the parties' joint motion to exempt the case from FOC services.
Thank you. Is that correct, Ms. Stutz-McCoy?
Yes, I would agree.
All right. I do see that the parties did submit the motion to opt out. It looks like the advice of rights has been reviewed and signed by the parties. So I'll just take some brief testimony from them. Ms. Pegg, could you please unmute?
Okay, I think I got it.
All right. Would you please raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, ma'am. And is it accurate that you have reviewed and signed an advice of rights regarding friend of the court services?
Yeah.
And do you have any questions regarding that form?
I do not. No.
And you are asking to opt out of friend of the court services, is that correct?
That's correct. Yes.
And are you making that decision freely and voluntarily?
Yes. Mm-hmm.
And do you believe that is in the best interest of the children?
Yes, I do, Your Honor.
It appears you've also reached an agreement regarding custody and parenting time, is that correct?
Yes.
You've agreed to joint legal custody and that you have the primary physical custody, is that correct?
Correct. Yes.
And you are not seeking child support in this matter, is that correct?
Correct.
And again, do you believe those agreements are in the best interest of the children?
I do. Yes, I do.
Thank you. Mr. Pegg, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And sir, it looks like you also reviewed and signed an advice of rights regarding friend of the court services. Is that correct?
Yes.
Do you have any questions regarding that document?
I don't think so.
And did you sign that freely and voluntarily?
Yes.
And you are also in agreement that you would share joint legal custody with the plaintiff having the primary physical custody. Is that correct?
Yes.
And there is no child support in this matter. Is that correct?
Correct.
And do you believe these agreements are in the best interest of the children?
Yes.
Well, based on that, I would grant the request to opt out of friend of the court services. Counsel, anything else you think I need to address today?
No, Your Honor, not to my knowledge. I do want to confirm that there was a proposed order submitted with that motion, and I want to ensure that you have the same.
Yes, I do see that.
Thank you.
Ms. Stutz-McCoy, anything additional?
No, thank you.
All right. Thank you for everyone appearing. You're all set and can sign off.
Have a good day, Your Honor.
Thank you.
Thank you.
DM, do we have the parties on that matter present?
Yes.
Yes, I'm here.
All right. We're here today on a motion of order to show cause regarding the non-appearance. The parties were to appear on November 25th to address the request to revoke an acknowledgement of parentage. I think on that date, neither party appeared. Ms. Pfeiffer, can you explain why you were not here in court on that date?
I was at work and it just completely went over my head that I had court, to be honest. I didn't set enough reminders, I guess, and I went to work that day and didn't realize till later that evening.
Okay. Mr. Walsh? Why did you miss court that day?
I was working on a roof over by Gaylord and I didn't have service on the phone. Well, my phone was broken, but I had to use someone else's and there wasn't service to call.
I just indicate to both of you that, obviously make sure you're mindful of when you have court dates scheduled. You could be held in contempt. You could have negative actions in your request. So make sure that you do appear. Given that you're both here today, I'm not going to find either party in contempt, but we do need to address the request to revoke the acknowledgement of parentage. There was a prior order requiring paternity testing. My understanding is that has been completed, and it indicates that there is a 0% probability of Mr. Walsh being a father. Is that your understanding, sir?
Yes, sir.
Now, you guys do have one other child together that is your child, is that correct?
Yes, sir.
Okay. So this just relates to the child that was born in 2016, correct?
Yes, sir.
Okay. Ms. Pfeiffer, have you seen those results and any reason to disagree with those results?
Nope. I agree with them 100%.
Okay. And ma'am, have you taken any actions to determine who the biological father is?
Yeah, we've known this whole time. His name is Ronald Vredenberg.
Okay. Have you filed any sort of support action or custody action in that matter?
No, me and him talk and get along and co-parent well. We were waiting for this to finish because I didn't know how this would play out. Well, I knew how it would play out because I already knew he wasn't the dad. He just agreed to sign when we got married like 8 years ago. So Ron knows that all this is going on and that he knows that I don't know how it works to put him on the birth certificate or however that works, but he does want his rights to like custody and shared time and all that. We already do all that anyways, but he just wants it on paper.
Does that child receive any sort of public assistance?
No, not anymore. I guess as far as medical assistance, but that's it.
All right, so the child is on Medicaid?
Yeah, she has 2 different kinds. She has the state kind, but then she has a disability kind as well because she has a disability.
Okay.
And I got a question too. For the child support that I was paying and all that too, is that all gonna stay the same, or is anything gonna happen with that?
Right, any past support that was paid is not recoverable. I think the court abated support at one point in this matter, so we stopped the support when this became an issue that the court was aware of. So until that request was made, we can't then go back in time. But your support, we would discontinue support based on the revocation of the acknowledgement of parentage. So I would grant the. Go ahead.
I was wondering because of the back pay and stuff like that too. I've been having issues with that. I've been paying.
I'm not sure.
I was just asking if it was still staying the same.
You're asking if your child support back pay, if you have the right to any of that?
No, I was wondering if it was all still staying the same, if I was still paying the full amount on all of it.
Well, you wouldn't be paying support for that child. Correct? But you have another child together, correct?
Yes. Which has been living with me and everything too, but the child support was still it was still kind of stacked up for both of them too for in the back pay. I was wondering if it's still staying the same or if it was gonna get cut in half or if I was still gonna pay the full amount.
As far as I know, they already stopped the child support for Caroline coming from him because of when the court proceedings started.
Correct. I do see an order that was effective back on to October 16th, where support was only for one child. But he's indicating that he has overnights with that child, and that order was based on him not having overnights.
My son lives with me.
Yeah, things have changed. We decided to put Sean with his dad this year, and so that's why we started all this paperwork to get Caroline taken off. Because we were married at one point. Sean signed the birth certificate for Caroline. We did live together, have a happy family. For years, he played as her daddy. And then as soon as her real father came around, he wanted to get taken off everything, which is his right and completely understandable. So, but yes, now my son has been over there and things need to change. And that's why we don't get food assistance or anything anymore, because they went and filed and did everything without speaking to me first.
Right, so hold on, for both of you, I'm just going to ask pointed, direct questions because we don't need to go through a whole backstory. So the question is, Ms. Pfeiffer, how many overnights do you have with the child you guys have together?
About every other weekend.
All right. Sir, does that sound accurate?
Yeah.
Okay, so it's every other weekend throughout the entire year?
As
yeah,
much as we can.
As much as we can, as much as she can take them based on her work and stuff too. But yeah, and we've had them for the past year since school's been out last year.
If the two of you are in agreement, what we can do is prepare a new child support recommendation with that change in overnights. It would be based on Ms. Pfeiffer having every other weekend throughout the year. Are you in agreement with that, Ms. Pfeiffer?
I'd rather just stop all the child support, to be honest. I'm done. Like, I think we're both very exhausted with dealing with the courts, and we don't want to deal with the courts at all anymore. Like, I want Caroline, I want him taken off of Caroline's, and I would rather just stop it all. But I guess I can agree to it.
Like, yeah, I would like her to pay child support if I had to. Like,
I'll pay child support. I'll pay your way. It's cool. Let's do it. Go for it.
It's not paying my way.
It is, Sean, because none of this came up until you started complaining
the two of you could take free time to bicker back and forth, okay? Which obviously you apparently need to have. So we're not going to do that here. This isn't your opportunity to go back and forth with your issues. All right, so based on what's been presented to the court, I would recommend that a new child support recommendation be prepared. Obviously, the court is granting the motion to revoke the acknowledgement of parentage related to Caroline. So the support would be based on the other child. It would be based on Ms. Pfeiffer having overnights every other weekend throughout the year. So a new support recommendation will be prepared based on that. And again, I am granting the motion to revoke the acknowledgement of parentage. And I would direct Ms. Pfeiffer to initiate a custody or support matter related to the child who's had the affidavit of acknowledgement of parentage revoked. It is appropriate then to have a court order that indicates who the father is, as well as the terms of any agreement that the two of you have. Also, if the child is on any sort of assistance, but it appears that there is assistance, there should be a support action initiated. Any questions, Mr. Walsh?
No, sir.
Any questions, Ms. Pfeiffer?
No, Your Honor.
All right, in front of the court, do you think we covered everything?
Yes, Your Honor.
All right. All right, thank you both for appearing. You are all set and can sign off.
All right, thank you.
399 DM. We have the parties on that matter present.
Yes.
Yeah.
Ma'am, the last name is Nichols now, is that correct?
Yes.
All right, thank you. All right, we're here today on, I think, competing motions regarding parenting time. Mr. Crowderfield, I'll start with you since you are the plaintiff. What change are you seeking to make?
I'm just trying to make a holiday schedule for both Haley and I so we can evenly spend the holidays with our child.
Okay. Your prior order did not address holidays, is that correct?
Yes, that's correct.
All right. So Ms. Crowderfield, as to a holiday schedule, what is your position on that?
The only thing. Oh, I'm sorry. Is it me or him?
I'm sorry, Ms. Nichols. Yeah.
Okay.
What is your position on the holiday schedule?
I agree with the days on the schedule. Everything else on this parenting plan, I don't agree with. And me and Hunter have had quite a few conversations about changing a lot of this.
All right. Do the two of you have any sort of agreement at this time, or do you need a hearing?
I mean, I think as far as we've discussed, we've came to an agreement, but I mean, I don't know how he feels at this moment.
Yeah, for the most part, we seem to have come to an agreement on the holiday schedule. I don't know, as far as times go, I mean, we can adjust the times if, so we're both on the same page, that's fine. I just sent out that holiday schedule, and we can send it out, we can talk about it and figure out what would work best for both of us and the child. So I'm willing to adjust times if we have to, do what we got to do. And I think we both agreed on the holiday schedule itself, though, is, pretty fair.
All right, so I do see a holiday schedule that was put together in some parenting plan. So that's the holiday schedule you're going to follow, or you're making changes to that?
If Haley agrees to that holiday schedule, then yeah, we can proceed with that.
All right, Ms. Nichols, do you agree with that holiday schedule?
Yep, I agree with the schedule, but just the exchange time on the day after the holiday or whatever it is on here. I think we agreed to switch that to 4:30, just more for convenience on both of us. Rather than the 6 o'clock.
Is that correct, Mr. Crowderfield?
Yeah, I do agree with that as well.
So I see some exchanges are at 6, so you'd want those to be 4:30. Is that correct?
Yeah, I just wrote that down kind of as a starting point for us to kind of start somewhere, and we did agree at 4:30.
Now I see also, though, there's other times where it says 11 a.m. is when it ends. Is that also going to be 4:30, or is that staying 11 a.m.?
I think those were for specific holidays. I don't have the schedule in front of me, unfortunately.
So, for example, Memorial Day says 11 a.m. on the day of the holiday to 11 a.m. on the day after the holiday. Also for Labor Day, Halloween, Thanksgiving.
Yeah, if Haley's fine with just putting those times right at 4:30, we can do 4:30 as well. That way it's one set time across the board, and there's really no confusion or no dilemma there.
Ms. Nichols, what's your thought?
Yep, I can agree with that.
All right. The only one I want to then address with you, so we can change those, but also Christmas Eve indicates 11 a.m. on that day until 11 a.m. Christmas Day. So that one, do you want that to be at 4:30 also, or that one to stay at 11 a.m.?
I would kind of like that to be at 11, just given it's Christmas, and that way Zoe will have time to spend with the other parent, the full Christmas day with the other parent.
Okay. Ms. Nichols, what's your thought on keeping at least Christmas Eve, Christmas Day exchange at that 11 a.m.?
Yeah, yep, that's fine.
Okay. So my understanding is then we're going to adopt that holiday schedule in the parenting time plan with exchanges at 4:30, except for the Christmas Eve, Christmas Day will stay as already in the plan, which is 11 a.m. Is that correct?
Yes.
Yes.
Okay. All right. And then, so Mr. Crowderfield, are there any other changes that needed to be addressed?
No, I think the only thing I really kind of want to understand is just the taxes with claiming Zoe. Haley had claimed her last year. She claimed her this year as well. I'm just trying to understand. Okay, so next year, will I get to claim Zoe next year, or how is this gonna work?
All right, well, the way that works is if the parties have an agreement, then that can become an order. If the parties don't have an agreement, then the IRS rules control.
Okay.
Ms. Nichols, what is your thought on tax exemption?
If I'm willing to do rotating, there was some bills from Zoe's birth and past due taxes we owed when we were married, and he wasn't able to pay any of that. So I took it as to try and pay all that off with taxes. I didn't even receive a tax return because me and him owed so much. And then as to her birth bills, I'm the only one that's been making payments on that. And this year I'm trying to use that tax return to pay those off. If he didn't claim her this year and leave it up to the IRS, I am open to doing a rotating tax schedule starting with him next year. But if he claimed her this year, then we're going to have to wait to see what the IRS chooses to pay it to.
All right, so Mr. Crowderfield, what are your thoughts? Do you want to have then the tax claim beginning this year, and then you guys will rotate year after year?
Yeah, I mean, I'd like to rotate. I thought it was already in our court order from what I was understanding.
All right. See if it's in there.
I'm fine rotating. That is not the issue. I'm just trying to. And Haley and I have discussed the prior medical bills for Zoe's birth. And unfortunately, I just haven't been able to the past year and a half. And that's something her and I can set up if we have to. I would just like to get taxes straightened around is all.
All right. When do you think you should claim her, and when do you think she should claim her? So who's claiming her for 2024? Who's claiming her for 2025?
I thought I was going to claim her for 2024.
Miss Nichols, are you in agreement with that or not in agreement with that?
My taxes are already submitted.
Okay.
So that's why I'm saying if we wait to see the ruling and then go from, whoever doesn't get it this year can claim it next year and then rotate the continuation after that.
All right. So, sir, she has already, sounds like, submitted the paperwork. You've already submitted your taxes for 2024? Miss Nichols?
Yes.
All right. So, sir, she's indicating she's already submitted. So if she would be agreeable to that, then she would have the even number of years, you would have the odd number of years. Do you wish to agree to that, sir, or not?
Just so we're on the same page, I just want to clarify, I am even years, she is odd years. Does that mean I would, let's say, for example, in 2026, I would claim Zoe for 2025? I would claim for the year before. Is that okay?
It's for the tax.
Yes, I do agree to that.
Yes. So she has 2024. You got 2025.
Okay. I just want to be on the same page with that. That way there's no confusion on both of us.
All right. Any other issues, sir?
I was unable to make the last hearing. I had some phone issues, and then I tried on the computer. I tried on everything. I couldn't get in. So I missed that court hearing. And I believe we were trying to establish an exchange time for when it's my week and when it's Haley's week. And Haley had said in the last court hearing that her and I have came to an agreement on a time. And yes, we have came to an agreement. So I figured while we're here, we'll just settle that as well.
Okay. What is that agreement?
I believe we agreed at 9:30, didn't we, Haley?
Yes.
Okay. So yeah, we'll
so
just
9:30 exchange. What day of the week is that?
That's on a Mondays.
Mm-hmm.
And how are you handling exchanges? Are you meeting at a particular spot?
It really all depends. Like Zoe has not been in daycare due to just daycare closing situations. So normally, how her and I would normally do it is one of us would take her to daycare Monday mornings, and then Monday after daycare, the other parent would pick her up.
Okay. Well, what do you want the order to be now? Is my question.
Just basically exchange times to be 9:30 because there's been times if daycare is closed or there's other situations that
So how is it at 9:30 happening?
well, that would be if she does not go to daycare.
Okay. So if she's not in daycare, so you would drop off at daycare if she's in daycare. If she's not at daycare, you guys are meeting somewhere at 9:30 or someone's going to someone's house?
We've been meeting right at the parking lot right at M&M. And that seems to have worked for us pretty good.
All right, Ms. Nichols, is that an accurate agreement on the exchange on Mondays?
Yes, would that be the same exchange time for daycare when she's back in daycare?
I don't know what that would be. It would be up to you guys. I guess I'm a bit confused. So if she's in daycare on Monday, whoever's week is ending is dropping her off at daycare, correct?
Yes, it would just be nice for that to be on time. If we're paying for daycare, then showing up halfway through the other parent's day that's paying for it, it'd be nice if she's there on time.
Okay. Yeah, so that's what we're trying to say from what Haley said was there's been times that Zoe has not been at daycare first thing in the morning. So that's why we're trying to establish this time so that way she has to be
so
at
what time
daycare
does she
by
have to what time does she have to be at daycare by then?
Daycare start time is I believe it's 7:30, and we're just saying for like days that we have days off, or if Zoe's going to be late going into daycare, if she can at least be there by 9:30 is what we're trying to get at.
All right, so the child should be at daycare no later than 9:30.
Yes.
Is that correct? All right.
Yes.
Ms. Nichols, is that correct?
Yep.
Okay. Does that resolve all issues, or are there other issues that we need to address?
There are other issues in this modification.
All right. I don't know if I've got time to go over all of your issues. I have a court case. But we've kind of turned this into a mediation session rather than a hearing. So
I guess,
how detailed are these other issues now?
Just the pickup drop off location, if we can change that to M&M, because that's going to the courthouse is way out of our way. And using an app, we've been communicating over text this past few months perfectly fine.
Is that it?
Yeah, that would be it.
All right. I think Mr. Crowderfield, you already said exchanging at M&M is okay with you. Is that correct?
Yes, I agree to that. Yeah.
Okay. And then, so Ms. Nichols, you're asking to use a app. Is that correct?
No, I'm asking to not use the app and continue to text.
Okay. Were you ordered to use an app?
No.
You were not ordered to use an app?
The app was my suggestion because there for a while, Haley and I were unable to really communicate and get along very well. But like she said, we had been communicating through text just fine. Okay. So I'm fine with just not doing it.
All right. So the parties are not going to use an app, just communicate through text. Do you think that resolves everything, Ms. Nichols?
Yes.
And you think that resolves everything, Mr. Crowder?
Yes.
All right. Well, I think we made it then. I do need to put you both under oath and ask you some questions just to confirm that. Mr. Crowderfield, I'll start with you since you are the plaintiff. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, sir. Is it correct that you are asking the court to change your order and put into place the parenting time holiday schedule that is found in the parenting plan that was submitted to the court, with the change being that exchanges will be at 4:30, except for the Christmas Eve, Christmas Day exchanges will still remain at 11 a.m. Is that correct?
Yes.
You're also asking that the court now order that you claim the child for tax purposes in odd years, and Ms. Nichols claims the child in even years. Is that correct?
Yes.
You're also agreeing that exchanges are on, for the regular parenting time, exchanges are on Monday. If the child is in daycare, the parent whose time is ending should have the child there by 9:30. Is that correct?
Yes.
And if the child is not in daycare, then you would meet at 9:30 at M&M. Is that correct?
Yes.
And that's the same exchange place for your holidays also. Is that your intent?
Yes.
Okay, so all exchanges there. Okay. And the parties are going to communicate with each other through text and not through an app. Is that correct?
Yes.
And do you believe that these agreements are in the best interest of your child?
Yes, I do.
Thank you. Ms. Nichols, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And Ms. Nichols, are you also in agreement that you two of you would do holidays based on the holiday schedule and the parenting plan, except that we will change the exchange time to 4:30 p.m. for all holidays, except for Christmas Eve and Christmas Day, it will remain an 11 a.m. exchange?
Yes.
And for tax purposes, you will claim the child in even years. Dad will claim the child in odd years. Is that correct?
Yes.
That on Mondays, if the child is in daycare, the party dropping off should have the child there by 9:30. If the child is not in daycare, you would meet at 9:30 at M&M for the exchange. Is that correct?
Yes.
And all exchanges will take place at M&M. Is that correct?
Yes.
And the two of you are going to communicate through text rather than a app. Is that correct?
Yes.
And you believe these agreements are in the best interest of your child?
Yes.
All right. Anything else you think we need to cover, Ms. Nichols?
Nope.
And anything else that you think we need to cover, Mr. Crowderfoot?
No.
And you are in agreement, sir, that this resolves your motion?
Yes.
And Ms. Nichols, you're in agreement that this resolves your motion?
Yes.
Okay. All right. We will prepare that order and send that out to the parties.
Thank you.
Thank you.
All right. Thank you for being here and thank you for working together. DP, do we have the parties on that matter present?
Yes.
Mr. Midget, can you hear me okay?
Yeah.
All right. You are very quiet for some reason.
Is that better?
Very faintly can I hear you. I don't know, Miss Midget. Miss Wiggs, can you hear him better than I can?
I cannot hear him at all.
Okay. All right. He's unmuted, but very, very quiet.
Can you hear me now?
Faintly.
I'm not sure my phone's turned up all the way.
All right. I can barely hear that, so we'll see if we can get through it without that audio being better, but maybe if you get closer, that'll help.
Okay.
That is certainly better, not great, but I think that is doable. Ms. Wiggs, my understanding is the parties have an agreement. Is that correct?
Correct.
All right. Could you please let me know the terms of that agreement?
Mr. Medea is to have the child every other weekend, beginning Fridays at 6 p.m., ending Sundays at 6 p.m. He is supposed to pick the child up on Fridays, and I am supposed to pick her up to return home on Sundays.
Okay.
But also, Mr. Medea is only to have the child at his father, Dennis Midiot's, or his sister, Bethany Midiot's, during visitation times until he can find his own stable place for her to go.
Okay.
She also is in sporting events, so sorry. During the sporting events, if the game happens on the weekend, then she'll be picked up and dropped off the night before and picked up and dropped off after we return for the remainder of the visit.
So there's a sporting event.
We have
take her.
Yeah, she has in wrestling, she has matches or meets that are on Sundays. So he would pick her up Friday and I would pick her up Saturday night. And then I don't know, we came to kind of came to an agreement stating that I would pick her up during the Saturday and then he's okay with just having her Friday during her sporting events, if that makes any sense.
I mean, it makes sense, but I'm trying to figure out the best way to word it. So if she has a sporting event on a Sunday, then she's coming back to you Saturday night, is that correct? Correct, unless he is able to take her to her sporting event. Then I could obviously meet him there. Okay. Anything else? During summer break and vacation and school breaks, it is still the same schedule as discussed. He just gets her every other weekend. During holidays, he gets her every day after the holiday, but Father's Day, he gets her the day, like Father's Day. Okay, so as to the other holidays, I guess I want to clarify. So he gets the day after the holiday? Yeah, so like to celebrate, he will get her the day after the holiday. Like Christmas, I get her the day of Christmas, he'll get her the next day. Okay. Is that the same then for Thanksgiving? Yeah, it's the same for every holiday besides Father's Day. He will get her the day of Father's Day. All right. And then just to clarify, which holidays are you guys considering holidays? Because people sometimes have different thoughts on that. So does that include Memorial Day? Does that include all those? No, Labor Day? It just Christmas, Halloween, Thanksgiving. Okay. So you're saying the day after Halloween he would have parenting time? Sorry, yeah, he would get her. Well, I mean, I guess not Halloween because that's not like a. Okay, so just Thanksgiving and Christmas. We get the day after. Correct. He will get her the day after. At what times? He can pick her up at 10 a.m. All right. Is that overnight or is that just a day thing? It could be an overnight if she didn't have school the next day. But if she has school the following day, then it would have to be like her get picked up at 6 p.m. We're just doing Christmas and Thanksgiving. There definitely won't be school the next day. Correct. So 10 a.m. until when the next day? It can be 6 p.m. Okay. All right. Any other terms that you think we need to address? No. Any discussions on child support? I was supposed to receive a paper and I still have yet to receive the paper. I don't know if it's like my mail or the mail, but I have not received a paper that I had to fill out for that. Okay, so you're requesting child support? Correct, yes. All right, so what we'll do is prepare a child support recommendation. So when we talk about, overnights, he has to have the child at either his father's or his sister's, is that correct? Correct. But during his parenting time, is he free to go places throughout the day? Yes, of course. I was trying to explain that to him.
Just so she has like a safe place to sleep, you know, and those are the most trusting people in his family. So that's
all right. All right, Mr. Midyet, you heard all those terms. Do you agree that those are the terms you're going to agree to?
Yes, but there's already a child support order, and I've already been paying on it. It's automatically taken out of my sister.
that is back pay. Sorry.
No problem. I know I do see an old order, but it was based on no overnights, so we would prepare a new recommendation. All right, so Ms. Wiggs, now can I have you raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, and ma'am, is it correct that you're asking the court to enter an order that would grant pairing time to Mr. Midyet on an every other weekend basis, Friday at 6 to Sunday at 6, with the receiving parent picking up the child? Is that correct?
Correct.
And there's also an agreement that his overnights will either be at his father's house or at his sister's house. Is that correct?
Correct.
And that arrangement would go throughout the year. And then for holidays, he would have every Father's Day. Is that correct?
Correct.
We didn't discuss a time for that one. So what time are you thinking for Father's Day?
He could pick her up any day or any time that day, whatever he prefers.
All right, well, we can say as agreed then if you want to do it that way, or if you want to set a specific time, we can. Do you want to start it at 9 a.m. and end it at night? I mean, I'm assuming school, well, that'll be in the summer. So is it an overnight on Father's Day, or is it just the day?
A day. So I guess.
All right. 9 to 6. Is 9 to 6 what you're thinking, ma'am, or late?
Yeah, 9 to 6, fine. It's fine.
So Father's Day, 9 to 6. You would also then have the day after Thanksgiving, as well as the day after Christmas, beginning at 10 a.m. and ending at 6 p.m. the following day. Is that correct?
Correct.
I'd also indicate, though, for weekends, if there is a sporting event and he is unable to transport the child to the sporting event, then you would get the child the night before at 6 p.m. Is that correct?
Correct.
And do you feel this agreement is in the best interest of the child?
I do.
All right, thank you. Mr. Midyet, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, you heard all those terms that I went through with Ms. Wiggs, is that correct?
Yeah.
And are you also asking the court to adopt that agreement?
Yeah.
And do you think that is in the best interest of your child at this time?
Yeah.
All right, thank you. All right, so we will prepare that order. We will also prepare a new support recommendation. In front of the court, do you need updated financial information?
I'll send it out if I need it.
Okay. All right, so she's going to review her file. If she does need updated information, she will send out questionnaires. I would just indicate that if you do receive a questionnaire, you need to make sure you get that back within 14 days, okay?
Thank you. Okay.
All right, anything else, Ms. Wiggs?
No.
Thank you. Mr. Midyet, anything else? Okay. All right, thank you both for appearing. You are all set and can sign off. Mr. Gildner, can you hear me okay?
Yes, sir.
And Ms. Wilson, can you hear me okay?
Yes, sir.
All right, Mr. Gildner, we're here today on your objection to a child support recommendation. Is that correct?
Yes, sir.
All right. Let me know then the basis of your support recommendation or your support objection.
Say that again. I couldn't hear you very good.
What is the basis of your child support objection?
Well, basically, I did the math, both this one and the next one, because the next one's mine too, comes to $11.87 a month. I only bring home $28.20 a month. I drive to Vanderbilt every day, 45 minutes. So between that, the expenses, the house payment, the water, the phone, both my parents live with me. They both have cancer. I have other responsibilities. I also am on parole. I have court fees, all that stuff. If it ends up being $11.87, I'm not going to be able to drive to Vanderbilt every day.
All right. Do you believe the appropriate income was used?
As far as I know, like my income on the paper, that it looked right. I didn't look too in depth at it, but I'm pretty sure it is.
Okay.
But the problem that we're running into, honestly, is that I have joint custody of both my kids, but both these women are not allowing me to see my kids. So right now I don't have any overnights, even though there's no reason for that. I have parenting time complaints, but they're not getting heard till, well, the first one's in March. So.
All right. Looks like your order in this matter was, I think, parenting time as the parties agree. Is that correct?
Yes.
And at this point, you're not agreeing on parenting time, it sounds like, and there's a hearing in March, so you're not having overnights currently. Is that correct?
That's true.
Okay. All right. So obviously, if it changes after that hearing, then the overnights would change. I haven't heard anything that necessarily addresses the guidelines, except for you said you are paying some type of restitution, fine, fees, or other costs associated with your conviction or incarceration. Is that correct?
Yeah, that and on top of everything else. Yep.
All right. Were those crimes related to failing to pay child support?
No.
Were they crimes against a child in the current case?
Nope.
Okay. Were they crimes against the other parent?
Nope.
Ms. Wilson, would you agree that the crime that he is paying those fees, fines, and costs for was not a crime against you or the child's sibling?
No, Your Honor, they're not related to myself or our son.
Okay. So the child support guideline in the deduction section does indicate that you can deduct from income recurring payments for restitution, fines, fees, or costs associated with that conviction or incarceration, as long as the crime was not related to failing to pay child support or a crime against the child in the case, or the parent or custodian. So it does sound like it is not. So, sir, you're making recurring payments for those?
Yeah, they're monthly payments, and I have a supervision fee. I have a tether until like March. So.
All right. So I'd indicate you can provide those costs to the front of the court. They will deduct those from your income and prepare a new child support recommendation.
Yes, I can have my PO write up something.
All right. So provide something to the front of the court. If they need something additional based on what you provide, then you need to comply. But I will indicate that based on the child support guideline formula, that is an appropriate deduction. I'm not going to change the overnights at this time since overnights are not happening. Is that correct, Ms. Wilson? Overnights are not occurring?
No, Your Honor, we were unable to agree upon a visitation or overnight scheduling, which is why we have the hearing in March, but there are no overnights at this time.
Okay. All right. So we won't make any changes on that. We'll see what happens in March. And we may, obviously if overnights change at that time, I would then order a new recommendation also. Anything else you want to say, Mr. Gilbert?
No, I mean, and so then it's just going to get recalculated and sent it back out to me. Is that how that works?
Yes.
Okay.
And you do have another opportunity to object to the recalculation if you think there are any other issues. Okay.
Okay.
All right. Anything else on this matter, sir?
Nope. Just hanging around for the next one.
All right, Ms. Wilson, anything else we need to address on this matter?
No, Your Honor.
All right. Thank you then, Ms. Wilson. You are free.
Thank you.
All right, the court will next call the matter of Gary Churches versus Joshua Kilborn. Mr. McCoy, could you please place your appearance on the record?
Honor Jennifer Dutzman-Coy on behalf of Gary and Donna Churches, who are present with me in my office.
Thank you. Do not see Mr. Kilborn in the court's Zoom room or in the court's waiting room. This matter was set for 11:30. It is now 11:36. So I will proceed on. Ms. Dutzman-Coy, what is the status of this matter?
Your Honor, the parties are the grandparents of the minor child in this matter, Mason. He's 2 years old. He's been residing with his grandparents since the death of his mother in April of 2024. There is no custody or parenting time arrangement there wasn't any at the time of Ms. Church's death, their daughter's death. And so we had filed this action to establish custody and parenting time with the guardians, who are the grandparents, but also to establish child support because none of that is being paid. And Mr. Kilborn is not providing any financial support of any kind while the child lives with his grandparents. He's been seeing Mason every other weekend, kind of inconsistently, not being uninvolved, but not having him on a full-time basis. And he's not really in a position to take him on a full-time basis. He's got some personal matters of his own, I think, that he's dealing with, allegedly going through a divorce. He is employed. He's not had stable housing. So the parties have requested paternity testing because we don't have a copy of the birth certificate. Allegedly, there's an affidavit of parentage that's been signed, but I do not have a copy of that. So we requested paternity testing and then to establish the custody and parenting time and the child support to be directed to the guardians. And the parties have been established as the legal guardians by the Otsego County Probate Court.
Okay. Are you requesting a evidentiary hearing?
At this point, I suppose we have to, yes, so.
So I've got some 1 hours available in March, but I don't know if you think 1 hour is sufficient.
I think so. I think it would be, actually, yes.
1 hour is okay, okay. So I've got an hour on March 19th at 11 or March 26th at 11.
All right, I think we'll take the 19th at 11, get it done sooner.
Okay. All right, so let's set the matter then for an evidentiary hearing on March 19th. That would be an in-person hearing. So there's never been, like, through the guardianship or anything, there's never been any support orders. Is that what you're indicating?
That is correct. Allegedly, Mr. Churches and the child's mother, Mr. Kilborn and Ms. Churches resided together. So I'm presuming that's why no order was ever completed.
All right, well, obviously, if we do a support recommendation, we can go back to the date of your request. I'm not going to order a temporary one at this time. So we will proceed forward then with the evidentiary hearing on March 19th. Any other issues you think we need to address?
Not at this hearing, Your Honor. Thank you.
All right, thank you. We'll see you on March 19th. We'll call the matter of Jerry Gildner versus Catherine Arms. Mr. Gildner, you can hear me okay?
Yes, sir.
And Ms. Arms, if you could please unmute, let me know if you can hear me okay.
Yes.
Thank you. All right, we're here today on Mr. Gildner's objection to a child support recommendation. Mr. Gildner, can you please state the basis of your objection?
It's the exact same thing we just kind of went through. I have the house payment, I have, utilities, I have the court fees, the parole stuff. It's the same.
And the case you're on parole for and paying fees, was that crime committed against Miss Arms or the child in this matter?
No.
Okay. Do you have any parenting time in this case, sir?
I do have overnights, but she's not allowing me my overnights. So I filed a thing for the court. I still haven't gotten a hearing date for that yet.
Okay.
But I do have
So Miss-
more than the average nights. I got like 140 overnights, 144 or something like that.
When was the last time that you had an overnight?
Just before I went to prison, 2021.
Okay. Ms. Arms, as to his support objection, anything you wish to say?
I wanted to state, I pay medical insurance for Madeline, which wasn't in there. Because my daughter turns 18 in May, so I didn't turn the stuff in. So I paid $275.04 every month for medical. And then I pay vision, I pay $866 bi-weekly. And dental, I pay $43.03 bi-weekly for her. As far as overnights, Mr. Gildner has not reached out to me or my daughter since he's been out. Even since he filed these motions, he has not reached out, and I can provide my phone records to prove that. That's pretty much. And we have court actually March 19th for a hearing for modifying parenting time.
Okay. But you said the child turns 18 in May?
Yep, May 22nd.
Okay. So it is under the support formula allowable to deduct from income recurring payments for restitution, fines, fees, or other costs associated with a conviction, as long as that conviction was not related to either failing to pay child support or a crime against the child or the parent or custodian. So, Ms. Arms, would you agree that the crime that he is currently on parole for was not against you or your child?
The crime he was committed for, those charges were just on his ex-wife Chelsea, but I was interviewed because it did happen to me when I was married to him and his previous ex-wife also.
Okay.
That's actually not true, Your Honor.
Well, we don't need to get into what's true or not there, because the testimony supports that your current conviction is not for a crime involving this parent or this child. So I would allow those to be deducted from his income. So we would prepare a new support recommendation based on that change. As well as if Ms. Arms has additional costs that were not included previously for healthcare related expenses that she is paying premiums for, she can submit those too. So Ms. Arms, if you are paying those, you need to provide proof of those payments to the friend of the court within 14 days, and they would be included in the new recommendation.
Okay.
Any questions regarding that, ma'am?
I did turn those in yesterday, but I do have another question. I have 2 other children that I take care of, my other children. Does that go along with the child support recommendation too? Does that?
Other children can be a factor. I don't know if that information was calculated previously or not.
It was not.
Okay. But your caseworker will make a note of that and may be in touch with you just to confirm that issue, okay?
Okay, thank you.
All right, Mr. Gildner, anything else on this particular matter?
My daughter's actually covered under mine. I have Medicaid, so or actually I have Molina. She's actually listed under there, so she does have medical coverage.
All right, well, providing the information you have regarding medical coverage, and we'll get it sorted out.
Yep, I did do that.
Okay. All right, any questions from front of the court?
No.
Nope.
All right. All right, thank you both for appearing. That does conclude the matter, and you may sign off.